Warm greetings and welcome to today's edition of the African Leadership Group, the Nigerian Leadership Series. My name is Itwa Igodalo, and I'm happy to be here today, having had a very, very busy day, extremely busy, too busy for my liking, but what can I do? I'm a young man trying to make a difference in Nigeria. So we thank God. Today, we're going to have a conversation that I somehow instigated. I met this old friend of mine, good friend of mine, at a function, and we started talking about the judiciary and what was going on in the judiciary and the last results of the election petition or the election tribunal. And he had some very, very interesting, strong, clear points of view. And I said to him, you have to come and share this with us on the African Leadership Group, the Nigerian Leadership Series. And he was very, very gracious to oblige. He's a lawyer, a corporate lawyer, what we call in Nigeria a senior advocate of Nigeria. That's like now what you call the King's Council in England. Very, very strong and very, very powerful people who know the law from head to toe, from side to side, and all that's in between. He was recognized alongside his team by His Excellency, the former Vice President of Federal Republic of Nigeria, Professor Yemi Osinbajo, for the assistance rendered to the Presidential Enabling Business Environment Council in securing Nigeria's elevation by 24 points in the World Bank's comprehensive analysis, comparative analysis of the ease of doing business. Okay, he was admitted into practice in England and Wales in 1989 and in Nigeria in 1991. He became a senior advocate in the year 2008. That's almost 20. One greeting and welcome to today's edition. Why is this buffering? Okay, 2008. That's about 15 years ago. 15 years ago, he's been senior advocate of the Federal Republic of Nigeria. He's a notable speaker. Speaking on leadership, public service integrity, personal and national development, and is an active member of the Justice Reform Project, a coalition of Nigerians across the legal profession. He has an accolade of very, very celebrated cases, including handling the election petition cases, Buhari versus Obasanjo 2003, Buhari versus Obasanjo 2005, El Gore versus Ahmed 2013, and so on and so forth. Please welcome with me today our guest, Mr. Osaro Eghabaimen, SAN Managing Partner, Pitson and Grace. Osaro, Domo, call.
Pastor, I don't know if you can hear me.
I can hear you. Can you hear me?
I can hear you clearly. I was almost embarrassed by reading all that out. I'm sure my together.
Yeah, I know how it feels. Sometimes when they read my CV to me, it's a bit of stress.
Yes.
In fact, I had to summarize it. I'm sure you know I had to summarize it.
Yes, I thought you just take a few things out of it, but thank you very much for that introduction. I consider it a privilege to be here, and I am ready to contribute to the discussions.
Yeah, thank you, Osaro, for agreeing to be part of the discourse today. The African Leadership Group is our own contribution towards leadership development, not just in Nigeria, but all over Africa. And we're, of course, very, very particular about Nigeria being our own Jerusalem. And we're anxious about how things have been in the past in Nigeria. Now we have a new government. We're hoping that they'll do much better, and so on and so forth. But our focus today is on this election petition tribunal that sat a couple of weeks ago and threw out the cases and passed their judgment and almost said that the APC government and President Bola Ahmed Tinubu have no case to answer and that all the charges were not acceptable. I'm not even sure they allowed one of the various petitions. And now both the Labour Party and the PDP have naturally gone to the appeal court. I'm also going to tweak you on the recent tribunal judgment in Kano State that also took asked that the governor there be replaced with the APC candidate, and get your opinion on that if you are prepared for that. But first of all, maybe you need to lay for us a background. Why do we have election tribunals in the first place? Is it part of our democracy, and is it part of our constitution? And what is the background to that? And can we really trust those tribunals? Since he who pays the piper dictates the tune, maybe you should just give us the background and the history of this electoral tribunal.
Okay. I think I lost the last few words, but I just summarize the question, give you a background as to the usefulness of tribunals and how they came into existence.
Exactly.
Okay. Clearly, when you have an electoral process, the resolution of disputes between the contesting parties is actually part of that process. And clearly, because you have more than one contestants, there's likely to be disputes, and therefore the tribunal is set up to resolve those disputes.
Is it the one? We can hear you. Go ahead.
Right. It will interpret the laws in accordance with the intent of this particular law. What is interesting, and when I go into more detail, is that the 2010, the Electoral Act of 2010 was actually repealed, expressly repealed. And therefore, the principles and the philosophy that will apply to this act, you first find from the act itself. In other words, from the words that I used. And if you can't find it, you start looking at the parliamentary debates and the committee reports that gave rise to the introduction of this act. It may be possible that some of the things I'll be discussing with you, it may be possible that the way in which the act was interpreted may not have taken into account that this is a new act, and therefore the old philosophy and the old principles were infused into the interpretation. And that's why you see that the petitioners lost their cases, because they approached the tribunal with what I consider to be perhaps a new philosophy, but the judges seem to be hell-bent on applying the old philosophy, and hopefully maybe the Supreme Court will moderate that position.
Right. Thank you very much. Can you therefore interpret for those of us who are not learned, or people of silk, or people of your beautiful profession, exactly what happened at that tribunal, what the cases presented before the judges were, and what the judgment was in a nutshell, so that we can really understand exactly what happened?
Okay, I'm going to focus on the points that resonate with the public. There are a lot of procedural issues which I may talk about if it is absolutely necessary. So, for the first time under this Electoral Act, the voters were required to participate in the process of actually seeing how the results are transmitted and then hopefully collated at the collation center. You know, in the past, when you go to the polling station, you vote and you're advised to wait to see your vote counted. But now, not only do you see the votes counted, there's a device which is referred to as BVAS now. And that device you're using capturing the biometrics of the candidate who is voting, so you're sure it's the right candidate, and you're sure at the end of the day that the number of captured individuals corresponds to the number of people who voted. You're also advised to wait to see that the results are transmitted electronically, and those results are transmitted to the INEC viewing portal, the INEC viewing portal, referred to as the IREV, okay? The collation officer is also required to obtain the physical copies that are delivered. So the deliverance is in two methods now. One is through the electronic transmission, and then the other is you take the physical copies, put it in a tamper envelope, and then you transmit it physically to the collation officer. When the collation officer receives these documents, he collates and then verifies that at least the EC8As, that's the first document used to record it, is correct, and it verifies that with the document that has been transmitted online. And you understand why that is done is because in the transmission physically, what we used to have in the past is you have people interrupt that transmission. And then at the collation stage, you also have a lot of malpractices because let's say you collate 5 and 10 from 2 EC8As, that's the original document recording the results, that should be 10. But we've seen situations where 10 become 1,000. So what the collation officer will do is to confirm from this electronically transmitted document that what he has physically corresponds with what has been sent to him through the electronic transmission. And if there's a dispute, he should rely on the electronic transmission. So that's the innovation that has been brought into the Act. That became a serious matter of debates in the tribunal as to whether that process is mandatory, and the failure to follow that process, because we all know now that at least the presidential election, the results were interrupted because they were not transmitted. INEC explained that to us. There's something they call an error TTP 500, which basically prevented the presidential results that were being transmitted from actually being delivered at their destination and distributed accordingly. So the petitioners argued that with the introduction of the new acts and the rules and the regulation, that process is mandatory, and if you don't follow it, is a non-substantial compliance. In other words, you haven't complied with the act, and that may in itself affect the outcome of the results. I'll go into some more details on what happened with the result, but that was their argument. The Court of Appeal held that that process was not mandatory, and therefore, as long as the physical transmission took place without interruption, or the petitioners not having proved that there was interruption with the physical process, the court held that the election was in compliance with the acts, and that was the main issue. I must add that the acts, there were a lot of arguments as to whether or not it was mandatory or discretionary. But one thing that, and thank you for giving me this opportunity, because I needed to read the judgments carefully. It's about 800 pages. One thing that is clear is that the object, what is referred to in the Act as the explanatory memorandum, memoranda, explains that the introduction of the electronic device is one of the main purposes for which this Act was enacted. And then it repeals the former acts. Principles that applies to the interpretation of the former act, you ought to apply it with circumspection. Okay? So I thought that what would happen ordinarily is that predominance will be given to transmission, even though it is not mandatory. And therefore, when there's an ambiguity about words, you bear it behind the back of your mind, dominant preference by this act. So that's how the Court of Appeal came to its decision. In other words, they consider this transmission as not mandatory, and therefore, even though INEC did not comply, it has no bearing on the election itself. And I think that's where people got disappointed, because remember, this is the first time the public were given the opportunity to actually view the transmission of the results. You could go there and see the results, and that result will correspond with what the collation officer used. So let me stop there for a minute.
Thank you very, very much for that very lucid and clear explanation.
Pastor, you are muted.
I have unmuted myself. Thank you very, very much for that clear and lucid explanation of the act. From what you read of that judgment and what is going on here, first of all, what were the grounds of the petition by both Atiku and Peter Obi and so on and so forth? And what was the response of the judges? And then maybe you can then say to us what you think from your own perspective as to that response.
So the two petitioners relied on the grounds that are expressly stated in the Constitution for challenging an election petition. And there are three grounds. The now president was not qualified to run the election because he had a criminal conviction in America. That was the allegation of some assets, because there became a considerable amount of debate as to whether that was a criminal forfeiture or a civil forfeiture. That's the first point. The second point was that the Independent National Electoral election in compliance with the provisions of the acts, and that the whole election was infected by corrupt practices. And the third reason is that the president now and the vice president were not elected by lawful votes. Those are the grounds that would normally be the petitioner, and that's what is stated in the act. So going to the factual situation, what that meant was, firstly, as I said, this question of relying on a forfeiture as a reason that the president was not qualified to contest. The second being that to transmit the electoral material was a substantial non-compliance. Some of the results that were downloaded IREV portal were blank, and therefore they did not reflect the true will of the electorate. And so they argued that there was substantial non-compliance and it substantially affected the outcome of the results. I think Labour Party also argued that two states specifically, even though many other states, but two, they were able to prove, demonstrate, I think in Benue and in, I think that's Port Harcourt, I think it was River States, that Labour actually won from the computations on the IREV as well as the fiscal computations. The other parties succeeded in using some technical reasons for that not to actually be investigated. So the experts, both experts of both petitioners, produced a huge documentary evidence, doing an analysis as to the number of votes that ought to have been disqualified, or votes that shouldn't have been counted. But those documents ultimately were never investigated for reasons which I'll go into later. And those are all technical reasons. At the time they were filed, they said it was late and all that. And then finally, of course, just demonstrating that the votes that were credited to both the president and the vice president were inflated votes. They were not votes that came directly from the voters. Those were the main reasons. The objection to the three main reasons were as follows. The reason that the allegation that the president is not qualified to run was predicated on a forfeiture of an asset in America. And the forfeiture arose from a case involving money laundering and narcotic trafficking, and generally involving dishonesty. And so, of course, what the Constitution says is that if you have a criminal record, you can't contest for the position of president or state governor or local government for that matter. The respondents, the defendants, the president's lawyers, were able to persuade the court that that forfeiture arose from a civil case as opposed to a criminal case. In other words, he had no conviction, criminal conviction. And they got a letter from the American embassy, which actually disclosed that the president conviction, notwithstanding the forfeiture. So that particular point failed. Of course, there was also the haven't been nominated to contest the position in the Bauchi Senatorial District, and then that interest before being selected. Again, that failed for technical reasons that ought to have been raised at a different time. And the main argument, of course, was this question. What the court held was that the electronic transmission was not mandatory. Now, let me go a bit more into detail on that particular point. So, for example, I think Labour, they actually were able to tender 18,000 blank forms, which should have had recorded in them the numbers that were scored by the candidates. Recall that I said earlier on that you needed to compare the physical collation with the information on the document from the documents you received through electronic transmission. So Labour argued forcefully that in the absence of that comparison, and to the extent that those documents were given to them by INEC, it definitely showed on the face of it a manifest malpractice, because there could not have been any verification. Those documents were given by INEC, yet there were figures recorded in favor of one party. The courts refused to accept that argument.
Can we hear him? Is he frozen? Sorry?
His network is frozen. I'm reaching out to him now.
Right, can you hear me now?
I think he's come back up. Yeah, you were frozen for a few minutes.
Okay, so I wonder where...
if you can go back.
All right, so let me rewind.
You said the courts... Yeah, rewind, if you don't mind.
All right, I said that the question about transmission is one that I wanted to go into in a bit more detail.
Yeah.
Right? And I said
that
I think it was the Labour Party had submitted 18,000 blank result sheets, which had been downloaded from the IREV, right? The court refused to accept that as having any probative value because of a number of reasons. One, because the person who tendered it, the court did not believe in that person. Two, the pleadings were not sufficiently particularized to relate, or the results were not sufficiently particularized, relating it to the units, and then reproducing that on the party's pleadings. That is the story by which you come to court. And so the court simply said, as long as there was some physical collation, that particular document, it refused to accept that it had any impact on the election, and therefore refused to accept it that it had a negative impact on the outcome of the election. I think that is where the problem lies for me. That's where the problem lies, because what the court did in refusing to accept that those results had any impact on the election, those blank sheets, was simply relying on the old principle and the old authority, because the new acts admitted that the act doesn't compel mandatory transmission, but the act actually compels a comparison between your physical documents and your documents that are produced virtually. In the absence of that comparison, there is obviously a non-compliance with the acts. In other words, you haven't followed the prescribed method. The prescribed method in the guidelines and the regulations. So there's another argument that the act simply says INEC will transmit the information in the way it prescribes for itself. That prescription was in the guidelines. And the argument is that because it is not specified in the act, it's not compulsory. But the way we normally interpret these things is that the manual and the guideline gives flesh to the act. And therefore, even though not compulsory, what should have happened was, if you give predominance to electoral transmission, it means that INEC had some explanation to do. If the burden will not continue to rest on the petitioner, once the petitioner has demonstrated that the act was not complied with, then it is now for INEC to explain firstly why not. And INEC haven't prescribed openly to all the parties, including the voters, that they were going to use this process. If another process was used, my position is that that process, you must demonstrate that it had integrity and the same level of integrity that electronic transmission should have imbibed in the entire scheme. But the Court of Appeal were not prepared to do that. What the Court of Appeal simply said is the burden continues to remain on the petitioner. And that was the old law. And the Court of Appeal went on to say each of the agents in each of the polling stations, and I think there are 176,000 polling stations, would have to come and testify. There are parts they said that, and I think that the Supreme Court, even if they come to the same conclusion like the Court of Appeal, will have to use language that demonstrates that electronic device has been introduced and we must use it. The Supreme Court will have to use that kind of language, even if they come to the same conclusion with the Court of Appeal. I want to stop there for a while, so I'm sure that I'm being followed.
Okay, you are being followed, and very soon we're going to be taking questions from the floor, and so on and so forth. So you made some points that the American embassy wrote a letter and said that the case was a civil case. Is that the normal process? Is it the American embassy that's supposed to write the letter?
No. The American embassy did not say the case was a civil case. The American embassy said they had written, I think, their intelligence unit or something, that the president did not have a criminal conviction. The debate as to whether it was criminal or civil, that was between the lawyers.
Okay, so they came back to say that the president didn't have a criminal conviction.
Prompted by a letter from counsel for the president.
Okay. So you're a lawyer. What exactly does that mean?
Well, I mean, in this particular case, not really much, because you can find that out through any means. I think what was important, which took a considerable amount of debate, was whether the forfeiture, because forfeiture is a very strong term, and the circumstance in which was forfeited, whether it had the same or should have the same level of negative connotation as a conviction. I think that's the lawyer spent a lot of time on that.
Okay. And then the issue that electronic transmission was not mandatory and they disregarded the 18,000 blank forms.
Yes. So that is where I think I will depart slightly. It seems to me that it is possible to reach the conclusion that electronic transmission is not mandatory. But what you cannot get away from is that electronic transmission is the predominant preference. If you look at the entirety of the act, and more importantly, if you look at the objective of the act or the object of the act, which is stated right at the beginning there, it's called the explanatory memorandum. It says the whole purpose of bringing in this act, amongst others, is to introduce electronic devices. So if you interpret the act in such a way that it diminishes the importance of the use of electronic transmission, you effectively undermine the entirety of this act, because that is really, in my view, the act enables INEC to introduce this electronic transmission. So it's an enabling act, correct? But if you look at the manual and the guidelines all over, it's about electronic transmission. And if you look at what was trying to be circumvented, is that a lot of the malpractices will normally occur after the election at the polling units, on the way from the polling unit to the collation center, and particularly the collation center. So what this would have done is to avoid all the malpractices at the collation center, especially.
So this is to say that the process that was probably adopted now for this particular election left room again for the malpractices we are trying to avoid ab initio.
That is my conclusion.
All
and
right.
that is why going forward, I hope that the Supreme Court will redefine how we use electronic devices for this for future elections. Very important.
Yeah. Well, we'll come to the Supreme Court very soon, and I want you to just hold your thoughts on what you think the outcome of the Supreme Court thing will be. But before we go there, I don't know if they tendered before the court. There were two states that they reputed had exactly the same results. Did you remember that, or was that not brought before the court at all?
I didn't see that in the 800 page. What I saw was specifically two states where, that's Rivers and Benue, where it appeared that, I mean, that's in the Labour side, where it appeared that Labour had scored, so they claimed they scored a higher figure than APC, both from the records on IREV and the physical records. Now, they also tendered evidence, both petitioners in many other states, which was embedded in the experts' reports by both parties. Unfortunately, those expert reports, due to some technical reasons, were not accepted. So we didn't have an opportunity to interrogate those many states. So it's possible that that was embedded in these reports that was never really interrogated.
What were the technical reasons why those expert reports were not accepted?
So when you file your petition, you're supposed to front load it with your witness statements and the exhibits within a certain period. And that period is sacrosanct. In other words, that time is, it's like when you're dealing with a bond, you know, heavens will fall if you don't redeem your bond on the day, or if you don't meet your obligations. So it is expected that you file that at that time. Now, both the petitioners cross-reference this particular document, and they indicated that they will be using this particular document as evidence at some point. But that didn't come within the time that is permitted to submit your petition. So that was one of the main reasons that it was rejected. Now, you'll ask me, is that right or wrong? It depends on how you interpret a particular philosophy. because the petition will state very clearly the grounds, the material facts upon which you're coming to court. The evidence by which you should prove that fact can come a bit later. If you take that interrogation as pure evidence, then the witness brought it at a time, and then the respondent's witness would also have an opportunity. They will cross-examine and they'll have an opportunity to bring maybe a different one. But the court refused to accept that. The court said, look, this is exhibit that is absolutely necessary for the other party to see well on time. And therefore, if you don't include it with the petition, you don't attach it to the petition, it will not be accepted. And that's actually what happens.
All right. So in summary, are you able to, without breach of any of your professional ethics, give your opinion and idea of this ruling or this judgment and point us to the pluses or the minuses, or if you are in full agreement with their what they call the judges of their judgment and all that, and if there are other areas or gaps or loopholes that Nigerians should have looked for, or what do you think? If you are sitting as a judge over this matter, what would your ruling have been?
Yes, professionally, I'm limited to what I can say, but let me tell you what I observed, which would be helpful. What I observed from the judgment is that I heard somebody say the judgment is a wonderful or fantastic judgment. If you were to take the judgments against the old law, that adjective, fantastic, may be correct. But if you take the judgment against the new law, I'll have my reservations. And as I said earlier on, this is a new law. I think there's a case that went to the Supreme Court, a Utola's case, that attempted to interpret some of the provisions, but we will need a full Supreme Court to introduce an interpretation and a principle that is in accordance with this new law. I think one of the things that perhaps the judges, perhaps there was not sufficient emphasis on is that this law actually expressly repeals the other law. Sometimes you introduce a new law, you don't repeal the former law. So you have to interpret that law in accordance with the former law, unless where there is a strict inconsistency. But here, the philosophy about asking agents to go and prove, all that is the old law. The new law focuses on documentary evidence, electronic devices. I did not see the Court of Appeal focusing on that. That is all I can say for now, and I will wait to see how the Supreme Court handles that.
It's very interesting that Nigerians would invest so much time and energy promulgating a new law to guide the authenticity of elections, spend a lot of time and energy putting in a process, electronic process, brought in machines, brought in training, brought in software, brought in men on the field and everything. And then on the day of the election, to just flippantly and willingly dismiss everything and say it wasn't important. Taxpayers' money spent, legal time spent, the time of the Houses of Assembly spent, drafting of a new law, promulgating a new law, everybody in agreement that this law will help our democracy, will strengthen our democracy, will give authenticity to the results, and all the hue and cry and all the noises made by INEC, threatening and insisting and all that, and lifting up the spirits and the hope of the people and saying that Nigeria was going forward, things were going to get better. And then just with the wave of a hand, the wave of a finger, tell us, all of us, that all these things are unimportant, irrelevant, and of no consequence. Yeah. It's very, very, very extraordinary.
Yes, and I think, Pastor, just before, and look, even if you make those pronouncements and you say that, look, electronic transmission is imperative, electronic devices ought to be used. And you still come to the conclusion that, well, the irregularities were not sufficient. I could even live with that. But to simply dismiss it, which is really what I found in the act, is something which we have to be careful how perhaps precedent is set on what we should do. Because no one spent time to look at the Hansard, to look at the committee debates, to look at the reasons why they were introducing this electronic device. And if you did, I sat in a committee many years ago after sitting in Obasanjo and Buhari that lasted 15 months, 13 to 15 months. We were in one court. And I decided to do something about that. And Mr. Shofunde, who I was working on that, had been appointed to sit in the committee. And he let me go and sit there. And we introduced this time-bound issue for the very first time since 2004. Now, we were interested in introducing into the system something that will improve what we had. And what has happened now is supposed to be an improvement. The decision of the Court of Appeal, if it stands like this, seems to be a regression with the greatest respect as far as electronic devices are concerned. I don't want to talk about the final results. That's a different matter, which hopefully the parties will go and slug that out in the Supreme Court.
Okay, so what do you think the Supreme Court will do? Let's now go to the Supreme Court. And let me just ask people who have questions or who want to contribute. Maybe there's some lawyers on the debate, on this thing, to bring their contributions, whatever their thoughts are. From where you stand, and if you had a prism or if you had the ability to look into the hearts of the justices of the Supreme Court, or even from precedents and previous judgments, what do you think the Supreme Court will rule, or do you think the case stands a chance there?
Well, it depends on the philosophical interpretation in the Supreme Court. The Supreme Court is a policy court. What I mean by that, they don't introduce policy, but they interpret laws for all other courts. If the Supreme Court adopts the philosophy that this is a new act, you find the intent from reading the act itself. And if you can't find that, you begin to look at the intent that led to or drove this act by looking at the explanatory memoranda, by looking at the debates in the House. If the Supreme Court takes that approach, I think there will be statements that are significantly different from what the Court of Appeal did. If the Supreme Court, however, takes the other end of the spectrum, which is what the Court of Appeal, they're using the old law. The Court of Appeal cited Awolowo and Shagari, cited many of the cases that I participated in, these old cases, Buhari and Obasanjo, Belgore and Ahmed, Olatunde Fashola and Jimmy Agbaje. All these cases were cited by the Court of Appeal, which basically was predicated on physical proof. Have an agent go, have your agents in every polling unit go and prove that there is malpractice. Impossible. I said we spent 13 months in the Court of Appeal in 2004 when Obasanjo succeeded. I worked for INEC. Again, Mr. Shofuni was leading me. And Ahamba, bless him, tried to obtain the election. And he did a good job, but it was Herculean. They just couldn't do it. And that's what led to the reforms. We seem to be going back there. So if the Supreme Court were to adopt a more progressive approach and rely on this electronic infusion into the system, you might be seeing different statements that are a bit more circumscribed.
All right. That's interesting. So it's just up to subjection now as to whether the Supreme Court would have a slightly a different interpretation or would uphold the rulings of the system. But maybe I would just ask you from where you stand on the state of our judiciary. Okay. What is the state of our judiciary? What is the state of our judges and our judicial system? Is there hope in the judiciary? Is it like most institutions in Nigeria? benefiting from the gravitas and the money flying around in society? Can we rely on the judiciary, or maybe you plead the Fifth Amendment, being a participant thereof, and you have no opinion? Well, it'd be nice to know whether we really can rely on the judiciary at this point in
time. Okay, so I'll make some disclosures and then I'll speak. I'm a member of the National Judicial Council, NJC, but I'm not speaking as a member of the NJC on this platform. I think it's important to make that clear. And what the NJC does is the body that is saddled with the responsibility to superintend over the appointment of judges, the discipline of judges, and all whatnot. In other words, they are responsible for the administration of justice and also for reforms. So I'm a member of that. I was appointed, I think, a year and a half ago. Olumide Akpata, I think, he nominated me without even consulting me. So I got in there, and I'm understanding the system better. And you ask me if there is hope. The system is troubled. We are facing a system that is almost broken. And therefore, there is need for everyone to get involved, particularly as to how we appoint persons into the Superior Court of Records, how we appoint judges into the Superior Court of Records. So let me explain what I mean. Most Nigerians will not understand that to be a judge is a huge responsibility. And you need a stern character because there's a lot of pressure on the judges, including the fact that many of them are not even paid that well. That's not an excuse. And that's why you must have persons of very strong character who go to the bench. And so when there are influences, whether monetary or otherwise, you can withstand those influences. And then you have to understand the law deeply for you to be able to really discharge your responsibility of adjudication. You know, as a judge, you're close to God. The judge is the only man who sends anybody to prison or who sends anyone to death, and there's nothing you can do. The power of the pen is very strong. So what you have in a system that is almost broken is that many who may not be qualified would apply to become judges. I had a very interesting discussion with a colleague only last week, and she's helping us. She's a lawyer. She's helping us with a very intricate land matter in Abuja. And she tells me that when she succeeds, I should make her a senior advocate. And I burst out laughing. And she said, why am I laughing? There are many people who are senior advocates who she thinks is better, even though she's not going to court for many years. So I said the system is troubled. It's not just about judges. For us lawyers, those who come into the law, we are really, law is a calling. It's something that you really need to be passionate about. And then you have to understand the ethics and the nuance that follows it. And it's from the lawyers you appoint the judges. So the system is troubled. I would only say that we all have a responsibility to see how.
The system is troubled.
Yeah.
So is there any hope in the judiciary?
Well, you know, I'm a very optimistic person. I run a marathon every year, and I run for improvement in the administration of justice. And through that means, that's why I think Olu Akpata appointed me there, nominated me, and the Senate approved my appointment. I am trying to, together with other progressives, I'm trying to see if we can change the system that admits those who would be elevated to the Superior Court or elevated to the Court of Appeal or Supreme Court, and those admitted as judges at the first instance court. So we all have to do something. I'm an optimist, and I continue to believe that it can be done. Where people are jackpying to, somebody stood their grounds and made it happen. We're very accustomed to complaining about the system. That's one thing I noticed. And I think what is said is that excellent people conquer the things that average people complain about. So rather than complaining, just like what you're doing, Pastor, setting this up, I think we all have a responsibility to make it happen. But to deny that there is no problem will be dishonest.
Thank you very, very much. Very succinctly and legally and essayishly put. And I'll leave you at that, since you are not on trial in this ALG court. There's some people who have lifted up their hands. They want to ask a question. They want to make a comment. I will turn it over to them. And maybe Pastor Sonny will help drive the question and answer session. I have Afolabi Ajidan, a gentleman called Bayo. I'm sure he's one of the people who jackpot from Nigeria. He's probably in the UK now. Emeka Wigwe, my old friend. And Pastor Funke Awolowo, who I think Jack, 4 people wanted to ask questions and make comments. Abi Ajidan, Emeka Wigwe, Funke Bayo, and then Funke Awolowo. Then we'll take another round after that. So Afolabi, my good friend, please go ahead. Unmute yourself, ask your question.
Sorry, good evening. It was not allowed. Can you hear me? Sorry, good evening.
Yes, Mr. Falabi, go ahead, please.
Yes. One thing that I wanted you to touch on was also a petition by the petitioners was this dual citizenship. What is it actually? What does the Constitution actually say? You know, I wanted you to touch on that. I also wanted you to touch on this FCT and 223 that government states and FCT. As this FCT and this FCT, has it been fully clarified now? If it has not been fully clarified now, how do you think it can be fully clarified for future elections? Or is it the possibility of FCT actually becoming a state? And finally, my last question is, Pastor had actually touched on it, all the petitioners' witnesses, all the evidences that they gave. I listened to the justices' judgments on that day. It took the whole day. And they went extra length to explain why they were not only throwing out, but quashing all the evidences by the petitioner's witnesses. But I did notice, however, that the justices accepted into their judgments the witnesses, the petitioner's witnesses on cross-examination, their statements. I don't know if you understand. The statements the witnesses made on behalf of the petitioners, the justices quashed them and threw them out. But on cross-examination by the current president's lawyers, the justices seem to accept the cross-examination words of the witnesses. I hope you understand what I'm saying now.
I do.
Okay.
So let me answer your question. Let me answer your question from the reverse and start with the witnesses that were their statements were rejected. I think I touched on it, a number of reasons, but one of the main one is that many of the witnesses that gave evidence on behalf of the petitioners submitted their witness statements outside the regulated period. There were some of those witnesses who were star or most important to the whole process, and they fell into different categories, and the reasons were diverse. But one of them was that a number of those witnesses came through a subpoena. In other words, they had applied to the courts to compel these witnesses to come in. And the because they had applied to the court, naturally, these petitioners needed the court's assistance to help compel these witnesses. But the court held that notwithstanding, the witness statement ought to have been front-loaded. And the petitioner's argument is that that's incongruous because these are witnesses that I cannot obtain their evidence until you sanction until you permit or you give me the authority to invite them. It's only at that point, and that's the reason why they do not fall within this bracket. There should be an exception with subpoenaed witnesses. The court rejected that. Now, the reason the court rejected that was partly because the court held that, well, the court didn't find, I found this in the argument, but the court just simply held, look, whether or not you're a subpoenaed witness, your statement must come at the prescribed time in the act. In other words, within 21 days or so of filing, something like that. Now, what had happened was that the subpoenaed witnesses, so the president's lawyers argued, a number of them did not need a subpoena. And there's a compelling force in one or two of that argument. They didn't need a subpoena, and therefore you were trying to circumvent the process by using the subpoena because you were late. But not all the witnesses fell in that category, in my view. So I thought the justices should have been more circumspect in the language they used, rather than simply saying all subpoenaed witnesses must file their statements at a particular time. Perhaps what one would have expected was that witnesses that were really subjected to subpoena, there might be exceptions to those witnesses. So that's one of the reasons they rejected it. They also rejected the expert witness on a number of grounds. One, that he hadn't shown an expertise. Two, that he was discredited. I don't think it was discredited because in one of the cases he had said, one of the questions put to him, he had said there were a number of local governments in Rivers State, and it turned out that there was not that number. And on that reason alone, I don't think that the document speaks to itself, and this particular act, the manifest discrepancy in the document should be sufficient to reveal, what discrepancy there is. You don't need anyone to stand behind the documents any longer. Okay. But when they got into the witness box, the president's lawyers were smart and asked questions. Those questions, they were able to use the statements to support their case. And that's a principle of law, that statements that are elicited during cross-examination can be used to support the petitioner's case. So that's that for the first question. Your second question on the FCT, I actually agree with the court here. And the simple analysis is this. Supposing, and this is my analysis, and it explains it graphically. Supposing the president had won in 32 states or 34 states, and you say he did not get 25% in Abuja, what you'll be doing, which is what the court held, is to provide a weighting for the voters in Abuja. You're giving them far more credits than they deserve. You're basically weighting their vote over and beyond every other Nigerian. I believe that for the purposes of this election, that's my belief, and the Court of Appeal held so, the FCT is treated as a state. So once you have 25%, once you have the 25% in no less than 2/3 of the state, that is sufficient. Abuja is treated as a state for that purpose. And the final question, dual citizenship, that falls under disqualification. It's possible, but again, that was not interrogated because part of that evidence fell into the category of evidence that was not admitted. Thank you very much. All right, next question. Well, I hope that answers your questions. Next question.
All right, thank you very much, Barrister Senior SEN. The next people, please limit your question to just one question so that we can have as many people as possible. We'll take the next three people, Bayo, Emeka, and Pastor Funke. We will really, really appreciate if you can limit your questions to just one and go straight to the point. Thank you very much. Bayo, you can unmute yourself and ask your question. Backroom, allow him to unmute. And then prepare Emeka also. And then Pastor Funke Awolo. Okay, if Bayo is not ready, can we have Emeka?
Okay, thank you very much, sir. Sorry, I think they just allowed me access to unmute now, so that's why. Good evening, sir. Thank you for the session. It's been so insightful. Thank you, sir. My question is really straight to the point, and it's that INEC, looking at the way the court process was handled, it seems like the burden of proof is mainly on the petitioners. So they have to prove everything, and all INEC has to do is to withhold some information or documents and all, and then everything is truncated. So the question is this: how should compliance, or who should measure compliance in an election? So INEC has given guidelines. So who should measure, or how do we measure the compliance, compliance rates on how the elections were handled, transmission, the entire process of the election? Who should take the burden of measuring that compliance, and how should it be measured? And that's the question. Thank you, sir.
Okay, thank you.
Thank you, Emeka.
Let's take two more so that you can take three at a time. Sorry. Emeka, go on. Yeah.
Yes, thank you very much. The presenter, the son. My question is straightforward concerning the judicial system in Nigeria. Is there anything like conscience?
Sorry?
Is there anything like conscience?
Conscience.
Yes, because out here, there is what they call the jury. The jury is where conscience applies, where question is asked, is this the truth? From your conscience, is this the truth? As opposed to the technicalities of evidence. Okay, because that is what the major question is in the Nigerian judicial system. Is there anything like conscience when it comes to the judicial system in Nigeria?
All right. Thank you very much, Emeka. Pastor Funke Awolo, the question. Thank you for keeping it short. Allow Pastor Funke to ask a question. Kindly allow her to unmute. Yeah.
Good evening. Good evening. Can you hear me?
Good evening. We can hear you. Go on, please.
I'm going to make two statements that will actually lead to begging the question. And I'm talking about retrogression here, because if they can go back as far back to Awolowo and Shagari, I remember following my granddad to the courts at that time with my other cousins, and I must have been 15 at that time. And even then, the case was, because my granddad was a SAN, he was not so completely satisfied. It was the infamous 12 2/3 case. And for them to go back, that means there's something wrong in terms of precedents and in terms of even what we call in science hypothesis, in the sense that with the beavers, there's nothing proven, there's no law protecting it. And then, like Pastor Itua said, we spent a whole lot, to make it happen. And then we're going to court, we're saying, it's not mandatory. And that makes it really funny. And I was reading the other day when Atiku said that it will be going beyond, the Supreme Court, because like I'm listening to you right now, it's sounding like it's a foregone conclusion. That means that they might dismiss it. And I just want to ask, what are the chances of taking this to the International Court of Justice? And in the case of rerun, because, we're going back to taxpayers' money and all that, what are the possibilities? That is my question. Thank you.
All right. Thank you very much. SAN, you can answer those three. Then if we have time, we'll take another three. Thank you very much.
Hello, I was talking to Pastor. Pastor's asking a question. Hello.
Hello, yeah.
Olu Victor. The pastor
Can
is
hear you.
asking.
Yes, we can hear you.
Final thing she said, she wanted to ask whether, I wasn't sure, because I didn't hear a final question, but she wants to know what can be relevant. But for specific purposes, like the question of this transmission is approved, I believe that technology has come to introduce a new methodology, which I think the Supreme Court, if that is the question she asked, I think I've answered that. Let me then answer the question from Mr. Emeka. Olu, do I go ahead?
Please go ahead, sir.
Go ahead.
Okay. So Emeka has asked that, is there a conscience? Do we have a jury system? No, election petitions by themselves are a peculiar type of proceedings. In other words, they say they're sui generis, they're sui juris, they are peculiar to their own methods. Infraction, the petitioner is out. So you really weighted against the petitioner. Do our judges have a conscience? Yes, I believe so. Have they decided in the way that you feel is the right thing? Well, as I said, there's a philosophical disagreement with the new act in my point of view, unless there is a conscience. That's all I would say. The last question was, how do you measure performance by the act? Would normally be the first to ensure neutrality and ensure that everyone is doing the right thing. Then the court, so the court plays a pivotal role in ensuring that everyone acts in accordance with the act. That is why we must pay particular attention to how the court resolves these disputes. So in terms of measuring performance, ultimately, the court is the custodian of reviewing what everybody else does and ensuring that it's in accordance with the law. Okay, Olu Victor, is that okay? Hello?
Yes,
Hello?
that's okay. We'll take the
Right.
next three questions. Thank you very much, Leonard Sik.
Okay.
We'll take Aki Faponda, Juliet Chinyere Amechi, yeah, and then we'll take Femi Olowe and maybe iPhone. So we'll take those four questions. Please limit your questions to just one. Go direct to the point so that we can put in. We have a few questions on the chat as well. So allow Mr. Faponda to ask his question. Unmute him, yeah. Allow him to unmute. Thank you.
Yeah, thank you very much. I appreciate the learner's sake for all the points he made. But he kept saying that we all have a duty, all of all Nigerians. Of course we don't. He is on the NJC. And how can my vote be equal to his own in reforming the judiciary? I think he has to assume greater responsibility for change. Somebody selling akara in the market cannot just assume the duty of changing the judiciary. That's number one. Comment. The import of FCT was that every street in FCT is occupied by all kinds of Nigerians. It's not like you have in any other state where you have Yorubas, Igbos, and all that. Abuja is the only place where the whole country is mixed up totally. You can't find a street belonging to Yorubas or Igbos in FCT. So the intent of I've been in Abuja since 1992. The intent of the draft was that you must command some respect in this small area that all Nigerians are together in a melting pot. But we lose that because we are dishonest. Thank you very much.
All right.
All right.
Thank you. The learner will respond to that. Femi Olowe, yeah.
You want me to go ahead or you want me
No,
to
no,
take
no.
the-
Let's take the next few comments, sir. Femi, go ahead.
Okay, thank you for giving me this. Okay, so my first question is that I want to talk on discipline. So I
Can
know
we
that
limit it
from
to
what,
one, sir?
oh, sorry, I will
Please.
not spend more than 60 seconds, please.
Okay.
So the NJC is in charge of discipline administration of the judges justice system in Nigeria. So I want to ask the learned sage that have we had a situation whereby judges in Nigeria, whether from a state or federal, is being disciplined or punished for certain delivery of judgment or any hearing behavior, and can he cite this type of examples to us done by the agency? The second one is this: does our speaker believe that this judgment from the Presidential Election Tribunal was right? If it was wrong, what type of incursion will the NJC do? And I also want to talk about the salaries of the judges. I know that NJC at one point recommended that the retirement age of judges should be 70. And I remember that Buhari approved it. So in the case of their salaries too, I also believe that NJC is saddled with this responsibility. Has there been recommendations to increase their salaries to what is competitive so that they can deliver their duties? And then the last point is, what are the loopholes in the 2023 or 2022 electoral acts? And do we have BVAS and IREV systems? We have them, yes, I know. But do we have clauses that are saying either IREV transfer of votes by IREV or by manner or other electronic means? If we don't have these loopholes, why is it difficult to interpret it as the same? And like I said before, if we have if we have this judgment to be wrong, what is the action or the actions? What are the actions that the NJC will take? Thank you.
All right. Thank you very much. I don't know who iPhone is. You have to state your name, please. Allow iPhone. I think that was the last we will take.
Okay. Yeah, Femi, your questions are.
I have not talked now.
Let me start with it is a big problem. I think in the last 10 to 15 years, the salary has been reviewed maybe once. But a committee has been set up now to liaise with the executive so that at par with today's economic reality. So there's the corresponding obligation to make sure that whatever is judiciary is judiciously spent. So there are two sides to it, but it is being looked into. We're hoping that this accordingly. The discipline of judges, yes, there are some judges who are disciplined. There are times where they're suspended. There are some structural issues because even when the NJC and claim that maybe he was not fairly treated, and that is his prerogative, the NJC itself is subjected to the court's interpretation. So there are some times when the NJC has taken action, a judge may decline that particular enforcement of the NJC's decision. Structural inhibitions which have to be looked into. That's why I say there are many issues when one gets to appreciate. But yes, there are some judges who are disciplined. Is the process sufficiently efficient? It can be improved. The other points that you raised, the question of the interpretation of this act, and if the judges are wrong, will they be punished? about philosophy of interpretation. There's a difference between mindset and eyesight. Eyesight and mindsight is how you interpret what you see. So the provision that gave rise to considerable amount of electronic transmission or transfer. The word or transfer, which means you can transfer it in any other method. So there is that small, if you listen to me, the court held that on that ground, electronic transmission is not compelled as such. And if you look at the act, I'm now talking about the manual. If you look at the acts, can you hear me?
Yeah, that is right.
Yeah,
Okay,
we
great.
can hear you, but
Right.
your network is a bit weak. But
Okay.
we're hearing you.
All right, I'll speak up. Can you hear me better?
Better, sir.
Yeah, thank you. So I'll just say to Femilowo that that, you know, the question you asked whether the judges will be punished, if it turns out that they were wrong. Liberty that a judge has, he has the liberty to be wrong, and but what I said was that they were enable you to reach one conclusion or the other. Object of the act, I think the predominance is electronic transmission, which means ultimately, for me, what has gone wrong, I should be the one explaining that the result it has declared has the level of integrity that an electronic transmission should. The body should be on INEC, but the body was not shifted to INEC. The body continued to remain with the petitioner. That's why I said the old law seemed to be the one that was used. So my answer to that question is, hopefully, if we can persuade the judges to apply a slightly different philosophy, that should be satisfactory.
Thank you very much. Juliet Chinyere, you can ask your question and then iPhone will come to you. Please go ahead quickly.
Okay, good evening, everybody. Yeah. Now, the Electoral Act 2022 that was amended is not yet watertight. Please, do you suggest that further amendments be made that will include the sanctions for false declaration of election results by the INEC? And again, considering the judgment passed by in favor of APC recently, are we really practicing true democracy in Nigeria, or is our own different, or is our democracy hijacked? Thank you.
All right, thank you. iPhone, you can unmute yourself and ask your question quickly. We'll take this too.
Is that me?
Yeah, that's you. What's your name?
Okay.
What's your name?
Yeah. Okay. Yeah. Hi. My name is Morrison Osifo, and I thank you for taking me. Thank you, son Eghabaimen. My question is a very simple one, and my concern is it your opinion that the election tribunal actually violated any aspect of our law in their judgment? If they did not, any need for this case to proceed to the Supreme Court? Because my understanding is that the Supreme Court does not adjudicate cases. The Supreme Court is supposed to interpret law. So if no law were broken at the petition, at the tribunal, what is the need to let this case go to the Supreme Court? Thank you.
All right. Thank you very much. Go ahead, sir.
Let me answer the question on, are we practicing democracy?
Let's see, is frozen.
We are
again.
practicing democracy. That's why we're in courts. And that's why we go to the Supreme Court. Okay, I'm frozen again.
Oh, okay, now we can hear you.
You can hear me.
Go ahead, yeah.
All right. I'm so sorry. I was just saying that look, practicing democracy, the fact that we're going to courts, the fact that we're having a system to select somebody else, the fact that we have a process to change a government as democracy. Are the institutions sufficiently strong enough? Are they sufficiently efficient to actually have a democracy that we would all be excited with? I think it can be strengthened, but we are practicing democracy. That's why we're having this discussion. If it was an autocratic government, we probably wouldn't be having this discussion. There probably won't be an opportunity to go to court. So we are practicing democracy, but I think that the institutions are extremely weak. And that's why you have some of this dislocation. The second question is by Morrison. He said, was there any law violated? And if there was not, why are we going to the Supreme Court? Again, whether or not a law was violated depends on the philosophical interpretation that you give to the act. If the court holds that electronic transmission is the predominant election, is the predominant option, it means that INEC not following that process, something has gone wrong. What should be the consequence? Should it be nullification, or should it be that INEC needs to explain that the results have the same level of integrity that an electronic transmission would have infused into the system? So whether or not a law is broken, putting it in that very loose context, will depend on what and how the Supreme Court interprets it. If the Supreme Court holds, like the Court of Appeal, that transmission is of no relevance to the process, because that's basically what they held, that transmission doesn't have any integral component, unlike accreditation. Some of us argue that perhaps the verification process is an integral process, and when you look at the object of the act. So it all depends on the interpretation. So if the Supreme Court comes to a different conclusion, then it means that it's not so much that a law has not been broken. It means that there hasn't been a substantial compliance with the prescribed law legal process. And that is a reason to challenge the election. Now, the consequence that follows from that is a totally different thing. Do we still rest on the substantial impact on the results? Maybe if we do, maybe if all those material that were jettisoned were considered, maybe we'll be able to come to that conclusion. I don't know. But the whole purpose of going to Supreme Court is to go and determine whether there was a substantial non-compliance, and the petitioners are well within their right to do so. Morrison is my old classmate. I'm sure that's why he's asking me a difficult question.
Okay, the lawyers that are in the house. I do have my own questions, but let me take Emeka Ugu Oju as the last person from the platform. Then I'll ask you one or two questions before we wrap up.
Please.
Emeka, go ahead. And
yeah, thanks for giving me the opportunity. My FCT. I think if somebody is not unique about FCT, then we'll be saying that P2B should be governing FCT, or at the very least, appoint the minister of FCT, since he won that state. But since it's somebody who's supposed to be the principal, that is technically the governor, and then at the same time, if not appointing the minister, what the heck are we talking about if we're saying that there's not something unique about FCT? That's what I want to point out, please.
You know.
Okay, it's just a comment. Go ahead, sir.
Yes. You have a right to your interpretation. When I read the Act and read the Constitution, the way in which it is drafted, it says, and the Federal Capital Territory. So it could be ambiguous, but when you look at the objects of the Act is to get a certain spread around the country, I personally will not give any priority to FCT. And as I did say, you can simply apply a graphic example that exposes the weakness, in my view, of that argument. which is that assuming that Peter Obi, for example, wins 35 states in Nigeria and doesn't win the FCT states, what you're suggesting is that another election must be conducted, whether it's Peter Obi, whether it's Atiku, or whether it's the current president. I would hardly be persuaded by that argument. I don't think that is the object, but we all have a right to our various opinions. Thank you.
All right, thank you very much for those answers. I have 2 or 3 quick questions, if you may. I wanted to find out, before the judgments were given and when the proceedings were going on, we had this movement that came up, all eyes on the judiciary. And some people thought that that movement was trying to intimidate the judiciary to do what they necessarily wanted. And I have never been to the court to hear a judgment. I'm not a lawyer, but listening to the judges give their judgment that day, they had very sketching words for the lawyers to the petitioners. They didn't have kind words for them. The way they berated them, as if to say they came to waste the court's time. They had very harsh words, and they said nothing about INEC. So my question is, were they sort of like angry that there was this movement on all eyes on the judiciary and they needed to prove, taking every issue line by line, that they had dealt with all their issues and that this was the conclusion they came to? Because that's my reading and the reading of a lot of people. I would like your comments on that. And then 2 is the judgment in Kano. You've not really commented on that. 165,000 votes docked from the NNPC or votes, and I was listening to some lawyers today talking about section 63(2) that said that even if documents are not stamped, signed, but it was from the stock of documents, INEC can use it and all of that. I don't know that section, and you could put more light on that. The 3rd one, if you answer, will be on the process of appointing judges in Nigeria, whether at state level or at federal level. Should we leave it for governors and presidents, or should, we completely take it away from them and have a totally independent process of appointing judges? Go ahead, sir.
Okay. So let me, in which you have asked your question, which that was used by the Court of Appeal had more or less, and perhaps ought not to have filed a petition. Such language, I think that courts, there you know where a professional, some arguments in their favor that I told you, which they agreed with it. I don't think that use words to suggest they're very good at coming under a new act. Many who the second thing was said of INEC, and I think that that's I think that's, and I see this is INEC. INEC gave nation, didn't even give a reason, an explanation. And I think somebody had asked an earlier to be amended. Maybe after the Supreme Court decision, ought to have been more responsibility and suffer the consequences of method that they themselves created. They had created what we call. So INEC really needs to cautioned. And so I agree with you entirely that certain documents that INEC had given to the other, they relied on the act to documents should not be admissible. To that in the past, you INEC, you are a party. Then we're going to get the justice of this case. It needed to be more scathing words against INEC. The results, I just mean certain things that be accountable and be held responsible. I'm not going to comment on that. I haven't read the judgment. I think it is to comment on any decision when he hasn't read the judgment. Judges, yes, that's something that I'm taking on very seriously. There's a process there. There's a process, but considerably. And with the fact that we are, and I believe very strongly, enhance the process of appointment, it will have a considerably on the way in which cases are decided.
All right, thank you. Thank you very much, sir. Pastor Itwa is back. I think we'll begin to take it home now for your closing comments. Pastor, if you are where you can talk, I hand over to you again, sir.
Thank you very, very much.
I didn't know.
Sorry?
So I didn't know that. Stretch
I didn't hear you. Sorry?
No, you were going to stretch me this much.
Well, I wanted to be a lawyer in my earlier life, and but I decided against it. I said maybe I should go and do business and make money. I didn't know that lawyers made a lot of money too. I thought they just spent a lot of time sweating in the courts and piling over files and reading documents. But now I know that you guys make a lot of money. You know,
I was trying to digest this journey. After taking it and giving that, wow, maybe I should have remained, which I was for some time.
You have remained a what?
A caterer.
A caterer. Oh, you were a caterer?
My mother is a caterer. My father is a lawyer.
Your mother is a caterer, your father is a lawyer.
I was doing catering from 91 to 94 and, you know, taking it to a different level. That business. But when you gave me this 800 people,
caterers make a lot of money too. You'll be surprised. Oh, I know an accountant who made a lot of money from catering to vessels and boats and ships. And
yeah.
Like you know.
Very, very good.
Yeah. So, Osaro, thank you very, very much for your warm contributions. The way you contributed today and what you spoke about, I almost thought that you were a King's College boy. But
but I'll tell you what, my government college Ibadan in Benin, but my grandfather always went to government college Ibadan. So
well, we forgive you for not going to the best school in the world and managing Swanston House and Carr House and those troublesome houses of those government children. Yeah. So thank you so much. Thank you so much. I think it was very, very revealing, very, very educative, very illustrative. And most of all, I think very, very balanced in your presentation of the facts and things like that. And then those of us who are here on the platform can take all that information and then decide on what conclusions to arrive at. My prayer really is that the judiciary will be strengthened. The judiciary will become the bastion of respect, the bastion of law, the bastion of resort for people. I also pray that the judicial process will be quickened. Sometimes a lot of people are discouraged by the amount of time it takes. I mean, you said some cases take 10 years, 15 years, 20 years, some even 40, 45 years. And sometimes the judges are so powerful, they rise, they say they are tired, there's no light, there's no this. And then this issue of longhand, I think they're doing something about it. So I pray that now that you are a member of the NJC, you will really seriously look at how we can make our judicial process more efficient, quicker turnaround, and definitely very, very credible, so that at least there will be an institution in Nigeria that people can beat their chest and say, these people are good. If we need to increase the wages or the pay of the judges, because they're human beings also, they must be very well remunerated for the effort, and they do put in a lot of energy and effort listening to those cases, reading of those cases, passing judgments. That might be some of your recommendations, so that indeed we can have strong institutions in Nigeria, which is one of our problems. No institutions that can defend the poor and the weak. So thank you very, very much. We thoroughly enjoyed this session. The questions too were quite robust, and shows that people are very interested in what's going on in Nigeria. We're hoping that from this ALG platform, we will be able to foster conversation, debate, involvement, inclusion, get various expressions, ideas as to how to build a greater Nigeria. But above all, inform the common people as to what's going on. I'm sure by the time we make public some of the things we've heard today, a lot more people will be better informed and know exactly what to do next time. And then also, if you and your colleagues have an opportunity to ensure that all our processes and all our efforts in Nigeria are not just casually rubbished, even by the institution for which those processes were made and put in place to make their work better, more credible, I think that will go a long way also. The whole thing was just totally rubbish. It was as though everybody was wasting their time in going through those processes. Very, very painful. And that's sometimes the story of Nigeria. A lot of effort, a lot of ideas, rubbished at the wave of a hand, but Nigerians keep accepting and keep tolerating all these things. I pray that the people that govern Nigeria will fear the people they are governing enough, and the God that put them there in the first place to do things right and things properly. Thank you very much, my brother. God bless you. God look after you. God bless your practice. God bless Nigeria. God bless the judiciary, and God bless our leaders in Jesus' name. I want to thank everybody on the platform and thank them for coming. And see you next week, 5 o'clock. I'm sure we'll have my brother Osaro back at some time in the future. Let me commit you. And maybe we'll be talking about other things at that time, but maybe something along the process also. Thank you. My regards.
Thank you. It's a privilege.
Thank you. Sonny Jumoke, Olu, thank you very much. Pastor Tayo, thank you very much for everything. I think we should try and have a quick meeting at some stage to review a few issues. Thank you. So Sonny, please try and work to put the meeting together. God bless you all. Thank you.
Thank you very much, Pastor.
Thank you all. Have a wonderful evening. See you again. Same channel, same week. God bless you.
Olu, who is coming next week? Do you know?
I will discuss it, sir.
Okay, and then the Honor Nigeria, we need to make some traction on that.
Yeah, I will conclude tomorrow and the letters will go out.
Maybe we should conclude tonight if it's possible.
Okay, no problem. I'll give you a call after.
Chief Mrs. Toli Godalo, you're enjoying San Francisco. God bless you. And thank Faye for me. Oh, he did quite a good job today.
Okay.
He's learning the role.
Yeah, he's learning very well, very quickly.
Pastor, when will you be free? I saw your call. I called you back, but
We can talk in a few minutes.
okay.
You can call me in another few minutes. I'm here.
Okay.
I trust we're off the recording.
Shade, where's my work? Oh?
Stop this recording.
Yeah.